A promissory note is a written promise to repay a debt. It is a type of financial instrument that outlines the terms and conditions of a loan, including the amount of money borrowed, the interest rate, and the repayment schedule. Promissory notes are often used in situations where one person lends money to another person or organization, and serve as evidence of the debt and the borrower's commitment to repay it. Promissory notes can be unsecured or secured. Unsecured promissory notes do not have any collateral attached to them, meaning the lender relies solely on the borrower's promise to repay the debt. Secured promissory notes, on the other hand, are backed by collateral, such as real estate or other assets, which the lender can seize if the borrower defaults on the loan. In some cases, promissory notes may also be traded or sold to third parties, allowing the original lender to recoup their investment by selling the debt to another investor. This can provide additional liquidity and flexibility to both the lender and the borrower. Overall, promissory notes are a commonly used tool for lending and borrowing money, and serve as a legally binding agreement between the lender and the borrower. What are the legal provisions involved in the promissory note? Promissory notes are governed by both state and federal laws. The specific legal provisions involved in a promissory note depend on the jurisdiction in which it is created and enforced. However, there are some general legal provisions that are common to promissory notes across the United States. 1. Validity. Promissory notes must be in writing and signed by the borrower in order to be legally enforceable. 1. The note must also clearly state the amount of money borrowed, the interest rate, and the repayment terms. 1. 3 years is validity for a promissory note in India. 2. Interest. Promissory notes may include provisions for interest, which is the fee the borrower must pay for the use of the lender's money. 2. The interest rate must be agreed upon by both parties and must not be excessive or otherwise violative of state or federal usury laws. 3. Repayment. Promissory notes must specify a repayment schedule, including the amount and frequency of payments. 3. In the event of default, the lender may seek remedy through the courts or other means, such as wage garnishment or the seizure of assets. 4. Statute of limitations. Promissory notes are subject to a statute of limitations, which is the time period during which the lender must take legal action to collect the debt. 4. The statute of limitations for promissory notes varies by state and can range from 3 to 10 years. 5. Dispute resolution. Promissory notes may include provisions for dispute resolution, such as arbitration or mediation, in the event of a disagreement between the parties. 6. Transferability. Promissory notes may be transferable, meaning the lender may sell or assign the debt to another party. 6. The promissory note must contain provisions allowing for transfer, and the borrower must be notified of any transfer. These are some of the key legal provisions that may be involved in a promissory note. It's important to consult with a financial advisor or attorney to ensure that the promissory note you're signing complies with all applicable laws and regulations. What are the legal acts and sections applicable in India if the amount did not repay? In India, if a borrower defaults on a promissory note, the lender may take legal action to recover the debt. The following legal acts and sections are applicable in such cases. 1. Negotiable Instruments Act, 1881. This act defines and regulates the use of negotiable instruments, including promissory notes, in India. 1. Section 138 of the Act specifically deals with the liability of the maker, borrower, of a promissory note in case of default. 2. Civil Procedure Code, 1908. The Civil Procedure Code provides the legal framework for civil litigation in India. 2. In cases of default on a promissory note, the lender may initiate a civil suit for recovery of the debt under this code. 3. SARFAESI Act, 2002. The Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest, SARFAESI, Act empowers financial institutions and banks to take possession of and sell the security in case of default on a loan, including a promissory note. 4. Limitation Act, 1963. The Limitation Act sets the time limit for filing a suit in a court of law. 4. In cases of default on a promissory note, the limitation period is 3 years from the date on which the borrower becomes liable to pay the debt. It's important to note that in India, the legal process for recovery of a debt from a defaulted promissory note can be complex and time-consuming. It's advisable to seek the advice of a legal professional in such cases. What are the precautions to be taken when lending money on promissory notes? When lending money on a promissory note, it's important to take precautions to protect your investment and minimize the risk of default. Here are some precautions you may want to consider. 1. Careful selection of the borrower. Do thorough research on the borrower's financial situation, credit history, and repayment ability before lending money. 1. Consider seeking the advice of a financial advisor or credit specialist. 2. Clearly define terms and conditions. Ensure that the promissory note clearly outlines the amount of money being borrowed, the interest rate, repayment schedule, and any other relevant terms and conditions. 2. This can help avoid misunderstandings and disputes down the road. 3. Secured promissory notes. Consider lending money on a secured promissory note, which is backed by collateral. 3. This can provide additional security for your investment in case the borrower defaults on the loan. 4. Proper documentation. Keep detailed records of the promissory note, including the terms and conditions, payment history, and any correspondence with the borrower. 4. This can help in the event that legal action is needed to recover the debt. 5. Diversification. Consider diversifying your investment portfolio by lending money to multiple borrowers and investing in multiple types of financial instruments. 5. This can help reduce the risk of default and potentially increase the return on your investment. 6. Legal advice. Consult with a financial advisor or attorney to ensure that the promissory note you're lending on complies with all applicable laws and regulations. 6. Legal advice can also be helpful in the event of default and the need to take legal action to recover the debt. By taking these precautions, you can help reduce the risk of default and protect your investment when lending money on a promissory note. Please subscribe for more videos.